Welcome, everybody. Welcome to today's episode of the Law of Self-Defense. Thank you all for being here today. Apologies for being a few minutes late. We should be streaming everywhere there is to stream. On YouTube, Twitter, and Rumble, as well as on, of course, the Law of Self-Defense member live stream. Before the end of the show, we'll be cutting off exclusively to the member stream for Q&A and comments, as we usually do. All right. Make yourselves comfortable. A shooting event in California. A 77-year-old homeowner found himself confronted with burglars. I believe there were 3 burglars. The homeowner had a gun, and he shot one of the burglars dead. I believe wounded another, but in any case, captured another in his yard, held him for police. Not sure what happened to the 3rd burglar. We'll see when we look at the news reports. But we're mostly here interested in the law, because this homeowner was arrested. He was arrested by the police on charges of murder for murdering burglars of his home. A lot of people are outraged, especially in a world of increasingly intense violence. It's funny. As an aside, I'll just mention that let's see, where is it? We're hearing because of course our president Joe Brandon is running for re-election against, of course, the great and powerful President Donald Trump. And of course, the propaganda lies have begun, claiming, the Brandon campaign is claiming that crime is falling in America. Crime is falling. Isn't that good news, folks? And they'll show you nice charts of crime going down, lots of down arrows in the graphics. The problem with this, of course, is that it's not really that crime is going down. Let me see if I can show you one of these charts that they're showing us. Oh, that's not the right graphic. Here we go. It's very amusing. Those of you paying attention know that we're becoming an ever increasingly violent society. You'll be forgiven for maybe wondering if that's the case, because we're being shown tweets like this. Kyle Griffin on Twitter, on X. The FBI just announced that crime has plummeted in the first quarter of 2024. Murder down 26%. Rape down 25%. Robbery decreased by 18%. Aggravated assault decreased by 12%. And you might be thinking, well, that's good news. Except what's being conflated, of course, is crime statistics and crime, because these are 2 different things. Because many urban center strongholds, politically, of President Brandon have simply stopped reporting crime to the aggregating agency, the FBI and Department of Justice. They just stopped counting. So if you don't count something, did it still happen? If you don't count the murder and the rape and the aggravated assault and the armed robbery, does that mean they didn't happen? Or does that just mean they weren't counted? Because what we do know is a lot of it's just not being counted. Democrat cities stop reporting crime stats to the FBI, including many of the biggest cities. So anyone you hear spreading nonsense about crime statistics being down, crime being down, rest assured that they're lying to you, as they really have to lie, because things are, in fact, so very, very bad right now. So hopefully we all know that. You're here at Law of Self-Defense. right? Our catchphrase is hard to kill, hard to convict. Got to be hard to kill first. The physical fight's the most important thing, or nothing else matters. So we ought to be prepared to defend ourselves and our family against unlawful criminal predation, and ideally do it in such a way that we're also well within the legal boundaries, and so not likely to spend the rest of our lives in jail for having been compelled to use force in defense of ourselves and our family. Anyone see the headlines from from Detroit over Father's Day weekend? See if I have that quickly. Here's one. Oh my Lord. Can you see that? 62 people were shot over Father's Day weekend in Chicago. In one weekend, 62 people were shot. Oh my gosh. Of course, that's only perhaps 2x or 3x what normally happens in Chicago. You think Chicago might have stopped reporting its crime statistics to the FBI because it makes the ruling party of Chicago and the President Brandon White House look bad? I think that might be the case. So we're here today to talk about this burglary event in California in which the homeowner got arrested and charged with murder. Can that possibly be the law in California or other states? You shoot a burglar, you're charged with murder. You're convicted, you spend the rest of your life in prison without possibility of early release. Or are we just supposed to let burglars rampage through our homes? What the heck is going on? That's what we'll discuss today. And with that, let's go ahead and launch the formal start of today's show. Well, hopefully the audio wasn't too messed up. I just realized I had an incorrect audio setting, but I've fixed it now. So if it was bad before, it should be correct now. And our sponsor of today's show is CCW Safe, a provider of legal service memberships. What many people mistakenly call self-defense insurance. In effect, they promise to pay their members' legal expenses if the members involved in a use of force event and facing legal jeopardy, either criminal or civil. They do a lot more than that. They also fly in their own investigative team that's working for you. Otherwise, the only detectives are working for the prosecution, the people trying to put you in a cage for the rest of your life. They provide lots of other benefits. Attorney Don West is their national trial counsel. He'll be consulting on your case. I think the world of Don as a criminal defense attorney and a good friend. Don just out of the blue sent me a very nice flat repair kit for my new Tesla that I purchased. Thank you, Don. I purchased that car on Don's recommendation, and it is in fact a pretty darn nice car. And any legal defense that has Don West advising it is head and shoulders above one that does not. Now, there are other companies that purport to offer similar services out there, legal services, legal protection services for use of force events. Some of them are worth considering. Some of them I like quite a bit. Others are dumpster fires. They are just trash that I would not recommend to my worst enemy under any circumstances. And it's important to know what you're buying. It's important that you have trust, founded trust, not just imaginary trust in whoever you're using to provide you with this kind of backing, to have your back should the worst happen. I personally trust CCW Safe. I'm a member of CCW Safe. My wife, Emily, is a member of CCW Safe. If you'd like to learn why I trust them, why I choose them over other options in the marketplace, go to lawofselfdefense.com/trust. And I have a very short video there where I explain exactly why I choose CCW Safe. And at that same webpage, you can also get a 10% discount code for your own CCW Safe membership. That's at lawofselfdefense.com/trust. Want you to make an informed decision, folks, on this kind of thing. And that's where you can get the information from me on why CCW Safe is the best fit for me and perhaps the best fit for you at lawofselfdefense.com/trust. All right. So where is the story? Uno momento, as my daughter's playing with duopoly would say. I didn't quite finish preparing the PDF. Let me do that now. And we'll get to the facts of the case. Now, this happened about a week ago, this shooting of the burglars. And I just picked up a news story from a couple days ago, which appears to be the most recent that is available. And that's what I'm going to, the most recent. I'll skip the earlier ones unless there's a need to take a closer look at those. All right. So, headline: 77-year-old Oakland homeowner released from jail without being charged in shooting death of suspected burglar. So he had been arrested on charges. They say on suspicion, but it's a suspicion of charges, right? Of committing a crime. The police have to have had probable cause to believe the homeowner had committed the crime, the basis for which they're arresting him, in order for the arrest to be lawful. Is released from jail without being charged in the shooting death of suspected burglar. He'd been held at the Santa Rita jail since Tuesday morning, a week ago. So this was updated, well, it says the 14th, but he was held in jail for a week. So the 77-year-old homeowner arrested earlier this week in the fatal shooting of a suspected burglar at his East Oakland house was released from jail Thursday evening without facing any charges in the killing. Alameda County jail records show. We have an Alameda County here in Colorado too, but this is Alameda County, California. Now, of course, they say without facing any charges. He was arrested on charges and held in jail on charges. What they mean is the prosecution has declined to charge so far. Prosecution reserves the right to charge you at a later date, of course, as the investigation continues and more facts are developed. The fact that the prosecutor's chosen to kick this guy free when they really don't have to, they ought to have to. Someone says the arrest was for the possession of an unlawful gun. It turns out the guy's gun was illegal. How a gun can be illegal is amazing to me. But the gun was illegal, I guess, under California law. We'll see how the facts develop here. The homeowner had been held since early Tuesday without bail on suspicion of murder. Well, that says he was held on suspicion of murder after Oakland police said he killed one of three people who were trying to break into his home while wielding a crowbar and a replica gun. Okay, so what do we have so far just in the facts? 77-year-old homeowner in his home, right, in his castle, in his highly defensible property, facing against three aggressors. So that's disparity of numbers. The disparity of numbers alone may qualify on as deadly force readily capable of inflicting death or serious bodily injury. Very difficult to defend yourself against three people if you're alone, even if no weapons are involved. But of course, it wasn't just disparity of numbers. They also had a crowbar, presumably for forcing entry into the home. That would be a burglary tool, itself a crime, possession of burglary tools in this context. But also, of course, readily usable as a deadly weapon. What is a deadly weapon? Anything that can, in the manner of its use, reasonably inflict death or serious bodily injury. Now, if you're using a crowbar to open up a crate of, let's imagine, brand new AK-47 rifles still in the grease that you legally purchased, of course, well, then you're not using the crowbar as a weapon, and it wouldn't qualify as a deadly weapon in that context. But if you're using that same crowbar to beat someone, is that use of the crowbar likely to cause death or serious bodily injury? Broken bones, maiming injury, loss of consciousness? Sure. So whether or not something is a deadly weapon or is inflicting deadly force depends on the manner of its use. The shoelace on your shoe, you would not think of as a deadly weapon. You would not think of as readily capable of inflicting death or serious bodily injury. But if you take it off your shoe and you wrap it around someone's neck, are you using the shoelace to inflict deadly force? Sure, of course you are. So here we have the crowbar, probably intended as a burglary tool, but also, of course, in the appropriate context, readily usable to inflict death or serious bodily injury. And then we have the replica gun. Now, presumably, the replica gun's not really capable of inflicting death or serious bodily injury. Certainly, one would think by the term replica, it's not capable of actually firing a round. Does that matter for use of force law purposes? Well, not if it could reasonably be perceived as a real gun. Because the law does not require an actual threat. The law requires a reasonably perceived threat in order to be justified in using defensive force. So if you reasonably perceive, if a reasonable person, hypothetical, reasonable and prudent person, would, in the circumstances at play, perceive that replica gun as real, and if the defender did, in fact, in good faith, genuine good faith, believe that replica gun was real, he can defend against it as a real gun based on that reasonable perception. And if it later turns out to be a non-firing replica, too bad. He still has his complete legal justification for the use of force in self-defense, presuming, of course, the other elements of self-defense are also satisfied. So the homeowner's release from Santa Rita jail came amid, you'd like to think Santa Rita would be a nice jail, right? Probably not, but what a pretty name. Santa Rita jail came amid a deadline for county prosecutors to file charges in the case, given the Alameda County Sheriff's Office general practice of not holding the suspects who have yet to be formally charged for longer than 2 days. Okay, so I guess he was in jail for 2 days, which is unfortunate enough. Though the jail's online record system said the homeowner was scheduled to be arraigned Thursday morning, that hearing never happened. A sheriff spokesman confirmed he was released due to a lack of charges in the case. They mean charges from the prosecutor's office. And the arraignment, of course, is where once you've been arrested and you've been booked and you're being held in a jail cell, the arraignment normally before, what can you call him, a junior judge, a magistrate, is where the formal charges are presented to you. You're asked if you understand those charges. You get to make a plea to those charges, invariably, of course, not guilty. And it's typically also where some kind of bail hearing would be held at the same time. But this guy's arraignment didn't happen. Does that mean it will never happen? No. If the prosecutor wants to charge him again, they'll charge him. He'll get rearrested. He'll get rebooked. He'll get for the first time then, he would be arraigned. The lack of charges in the case came as little surprise to several Bay Area legal observers who said state laws often protect homeowners from prosecution when they open fire on intruders on their property. Well, that's a rather ambiguous statement. We have to keep in mind that this is being written by a journalist. We rarely send our best and brightest to journalism school. It's not common in my experience for journalists, no offense to the journalists in the audience, for journalists to have an IQ comparable to whatever the room temperature is where they happen to be working. There's no state in the country where you can open fire on someone simply because they're on their property. That doesn't exist. You don't get to shoot simple trespassers anywhere, not even Texas, much less California. So there's no state whose laws protect homeowners from prosecution when they open fire on intruders on their property. If we read that statement literally, there has to be more to justify the use of deadly defensive force than simply having an intruder on your property. Continuing with the article, some also noted that prosecutors must believe they can prove the case beyond a reasonable doubt when filing charges, rather than relying on the police standard of having probable cause to make an arrest. Well, it's true that those are the two different legal thresholds for arrest and for charging, but it's very misleading. The police need to be able to articulate that they have probable cause to make an arrest. Do they genuinely need to have probable cause? I mean, do we have mind-reading machines that tell us the police actually believe they have probable cause? They did a formal probable cause analysis before they made the arrest? That's not what happens in the real world. The real world, the cops look and they say, something bad happened. This guy did it. We're going to arrest him, put it down the pipeline, let the prosecutors deal with it. That happens all the time, folks. That's the norm. Cops are not lawyers. They're not prosecutors. They're not judges. They're not doing an in-depth legal analysis. They need to have enough so the department's unlikely to be sued for an unlawful arrest. And the first part of this, prosecutors must believe that they can prove the case beyond a reasonable doubt when filing charges. Well, that's not really true either. That is the legal standard, but the operative word here is not must. They can prove the case beyond a reasonable doubt when filing charges. That's true. Must implies there's some kind of compulsion there that charges can't be filed unless they actually do believe. We see cases all the time where charges are brought where no rational prosecutor could have believed that they could prove the case beyond a reasonable doubt. The George Zimmerman case, the Kyle Rittenhouse case, certainly not on the legal merits and the facts available when they bring those charges. Prosecutors can bring charges on any basis. I mean, there's supposed to be a legal threshold here, at least a probable cause legal threshold. So, for example, a grand jury indictment doesn't require proof beyond a reasonable doubt. That's the prosecutor seeking charges, an indictment to bring someone to trial. At trial, he has to prove guilt beyond a reasonable doubt. And it would be nice if prosecutors didn't bring charges in the first place unless they saw a path to proving guilt beyond a reasonable doubt. But if prosecutors want to, they bring charges on a whim for political reasons. Happens all the time. So must is the wrong word there. Could they have charged this guy? I mean, just look at the Daniel Penny case in New York, right? The subway chokehold case. There's so many. Let's see. Charges came as a surprise. The DA is taking the appropriate level of circumspection on making sure they get this one right one way or another, said Steve Clark, a Bay Area attorney and legal analyst. And I think a quick decision one way or another would be a mistake until they reviewed all the evidence. Okay, that's nice, especially if it's true. I don't know how this, I believe this Steve Clark person is probably speculating. I don't think he's spoken to the prosecutors and asked them their rationale for how they're proceeding. I expect they're reacting to the political dynamics here in a more positive way than usual. In other words, they see all the headlines in the papers. 77-year-old man has been arrested for murder when he was fighting off burglars. That doesn't look good. That looks like crime is so out of control that the prosecutors are favoring gangs of deadly weapon armed burglars over 77-year-old homeowner. Is that the kind of message that would serve the interests of President Brandon and the Democrats that run California? Is it in their political interest that the public believe that the government is favoring roving gangs of deadly weapon armed burglars over 77-year-old homeowners? They've got to make that story go away, right? But in any case, DAs should not bring charges unless they believe that when they get to trial, they'll be able to prove guilt beyond a reasonable doubt. That said, they do routinely, normally, in the normal course of business, make quick charging decisions one way or the other. They do all the time. And by the way, when we talk about prosecutors making charging decisions, keep in mind, this is not like the 50-year-old elected prosecutor typically making this decision, unless, of course, it's a politically charged case, in which case the George Soros financed prosecutor might be making a quick political decision to bring a case to trial. That happens all the time. But many of these charging decisions are made by people who are prosecutors for a year or two. You know, our good friend Steve Gosney is taking a job with the prosecutor's office in Miami-Dade County down in Florida, moving over from the public defender's office. A great opportunity for Steve. I'm super happy for him. But that prosecutor's office is like 500 prosecutors. I mean, Miami-Dade, it's a huge metropolis, lots of crime, lots of prosecutors. And they hire 100 prosecutors a year, new. That means they're not increasing the total number of prosecutors every year. They're 100 are leaving to go into private practice, and they're hiring 100 new ones. That means every year, 20% of the prosecutors in Miami-Dade are brand spanking new prosecutors. And they're making charging decisions. How informed, how in-depth do you think the legal analysis is on those charging decisions? The Oakland Police Department's communications team declined to comment Friday, saying only that the matter remains an open investigation. So they reserve the right to prosecute later if new facts are developed. Here's some facts about the case. Police were called shortly before 6 p.m. Monday after someone saw two men and a woman, at least one of whom was armed with a crowbar, breaking into the man's house. So, is this a forcible and unlawful entry? We'll come back to that terminology in a moment. Certainly. Forcible and unlawful. They were not innocent intruders, right? They were not unintentionally in the wrong house. They weren't repair people sent to the wrong address who were told the homeowner can't be there, the door will be unlocked, just go in and fix the dishwasher while he's at work. They know they're breaking in. There's no innocent excuse for using force to break into someone's property. The burglars were confronted by the homeowner after at least one of them tried scaling a back fence. When police arrived, they found the homeowner pointing a Colt Python .357 revolver, which authorities later said was reported stolen out of Eureka. It's hard to believe a revolver wouldn't be on the approved list for California, but you know how gun control fascists work. They're not rational. But perhaps it was simply that the gun was reported stolen. He was pointing a Colt Python .357 revolver at one person, while a man believed to be in his 40s lay wounded just inside the back fence line. So not in the home, right? On the property. Paramedics later pronounced him dead. His name has not been released. Yeah, getting shot with a .357 is a pretty good way to end up dead. A third suspected burglar, a 37-year-old man, less than half the age of the homeowner, fled once the homeowner opened fire, but was captured a few blocks away by officers. He has since been charged with first-degree burglary, to which he has pleaded not guilty. Jail records showed he remained in custody Friday morning with his bail set at $50,000. Oh, California is not just going to release him on his own recognizance so he can run away and burglarize someone else's home? At a press conference Wednesday, Shavies, did I miss who Shavies was? Oh, acting deputy chief, Frederick Shavies. At a press conference Wednesday, Shavies largely pinned the homeowner's arrest on the fact that he did not provide a statement when questioned by homicide investigators. So what did the homeowner do? He did the smart thing. I don't know who called the cops. It could be someone who heard gunshots. Although gunshots in Oakland are like, orders for fries in a McDonald's. But in any case, the police were called somehow. The police arrived on the scene. They find the circumstances as just described. And they asked the homeowner, hey, what happened? The homeowner says, I got nothing to say. And good for him. I got nothing to say. I want my lawyer. I assert my right to silence. I assert my right to counsel. That's what we advise at law. Those are the magic words. You can't go wrong. Now, you may end up arrested, as this guy was arrested. But if you've shot someone and they're dead or dying, and that's the situation when the police show up, you should presume you're going to be arrested. Almost anywhere. Now, if the bad guy's in your house and you can prove you're the homeowner, maybe you won't get arrested. You got a better shot there. Of course, here the bad guy wasn't in the house. He was out in the yard, which raises an important question. We'll come back to that in a moment. And then we have some nice statements by defense attorneys that I completely agree with, but I find remarkably naive. One here, I find it very troubling that the police would arrest someone because they didn't make a statement, said Matthew Martinez, an East Bay defense attorney who previously spent 13 years as a prosecutor in Merced County. He continues, you have a Fifth Amendment right not to incriminate yourself, and the fact that you exercise that right doesn't seem like a reasonable basis to arrest somebody. Well, of course not. That's not a basis to arrest anybody. But that's not all that happened here, Attorney Martinez. I mean, let's be fair. This old man wasn't sitting on his front porch minding his own business. Nothing had happened. And police walked up and said, will you speak to us? And he said no, and they arrested him for not making a statement. That's not what happened. What happened is the cops showed up to a crime scene with this guy holding a gun, and he just shot somebody who died. And they asked him, what happened here? And he doesn't want to give a statement, which is very prudent. But there are other facts that the police are looking at. They didn't arrest him simply for not making a statement. They arrested him because They believed they had probable cause that he'd shot somebody, perhaps unlawfully. Now, do I think the police should have more of an analysis to make than that? Maybe. But what if they showed up and they find the same scenario, except the person holding the gun is the burglar, and the person who's dead or dying is the homeowner? Now, when the cops show up at the scene, they first look at, they don't know. And if no one's making any statements, how would they find out? So the common practice is for the police to just cuff people up. Should the standard be higher than that in the real world? Well, if you're a normal law-abiding person like us, of course you say, yeah, the standard should be higher. I don't want to get arrested on that basis, especially since I know I was doing the right thing. I was just defending my home. But keep in mind, when the cops show up to a violent crime scene, it's rarely a bunch of good actors. It's normally a bunch of criminals. And it's easiest for the cops to cuff people up and let the prosecutors deal with the aftermath after an investigation has been done. It's certainly safer for the cops. Yeah, we'll talk about curtilage in just a moment and what curtilage actually means. Okay, so continuing here, Daniel Horowitz, a Lafayette-based defense attorney, pilloried the police department's explanation. He and other attorneys in the Bay Area stressed that people have to articulate facts for why they believe someone committed a crime, rather than let someone's silence fill in the gaps. I can tell you the police arrest people who are not making a statement all the time if there otherwise appear to exist facts that would support a criminal charge. Horowitz continues, it's really incredible to arrest someone just simply because there's someone dead in your yard. Is there? I don't know. Should there be? I guess that's a different question. The police find a dead person and someone holding a gun, an arrest is highly likely. If there's just somebody on your property and you have a gun and you shoot them, that's not sufficient to arrest them. It just isn't. Well, that's a question that would be argued in court, I suppose. I can assure you these facts, these circumstances result in arrest a very high percentage of the time. And I'm a criminal defense attorney. I'm sympathetic with these arguments. I'm just telling you what reality is. These attorneys can put on their William Shatner shocked face all they want. You better presume you're getting arrested under these circumstances. The case represents another test of California's castle doctrine that generally gives homeowners the ability to protect their life or property from anyone trying to break in or cause harm. Well, that's not a proper understanding of the castle doctrine in California or anywhere else. You have a right to protect your life, period. Even in the absence of someone trying to break into your home, right? Your right to protect your life is not conditioned on someone breaking into your home. So the whole protect your life thing is completely independent of the castle doctrine. What the castle doctrine does, properly understood, is if you would have had an obligation to retreat, if you were in a fight out in a public street, if safe retreat was possible, you're relieved of that obligation to retreat if you're defending yourself from an intruder in your home. That's all the castle doctrine means. Now, there are other laws that do create special provisions for the use of deadly defensive force in your home, provisions that would not apply if you were in a public street. So you're getting a benefit from defending yourself in your home. Those special provisions are not properly termed castle doctrine. They're just not. Castle doctrine has one definition that applies in all 50 states. If you would otherwise have had a generalized legal duty to retreat before defending yourself, you're relieved of that legal duty to retreat in your home, period. It only addresses a legal duty to retreat. Now, California, by the way, some of you will be shocked to hear this. See if I can find the jury instruction real quick on this point. We'll be coming back to it in a moment. Here it is. California is not as liberal as it is. You might think it's a duty to retreat state. It imposes a legal duty to retreat before you can act in self-defense. It is not. California is a stand your ground state, a very aggressive stand your ground state. Now, they don't have a stand your ground statute. Often journalists will say there's 17 stand your ground states in the country to make it seem like it's a minority position. Well, what they're looking at, the journalists, is they're looking for statutes that are stand your ground. But there's two ways to have laws, folks. One is statutes. The other is case law. appellate court decisions, which are equally as valid as statutes in the creation of law. About half the stand your ground states are statutory, and about half the stand your ground states are based on case law. California is one of the latter group. There is no stand your ground statute in California, but California has case law, appellate court decisions, including the California Supreme Court, going back to the 1800s, making clear there's no legal duty to retreat in California. And this is the relevant California jury instruction, Cal Crim 505. We'll come back to it in a moment because it has other provisions, but a defendant is not required to retreat. He is entitled to stand his ground and defend himself, and if reasonably necessary, to pursue an assailant until the danger of death or great bodily harm has passed. This is so even if safety could have been achieved by retreating. That pursue an assailant language, there might be one other state that has similar language in its stand your ground law, but if there is, it's the only other one. Collectively, there are 39 stand your ground states. So about 80% of states are stand your ground. It's duty to retreat that's very much the minority position in America. Most states, the large majority, are stand your ground states. California, and maybe one other, includes pursue an assailant language. That's very aggressive, stand your ground. So, back to the article. Now I have to find the article. So what allows this this language about breaking in is not the castle doctrine of California. I mean, breaking in could be part of how an intruder got into your home in California. But the castle doctrine, the law that relieves you of a duty to retreat, doesn't care how the intruder got into your home. It's just there's an intruder threatening you. You're defending yourself against an intruder. You don't have a legal duty to retreat under those circumstances. Of course, in California, you wouldn't have had a legal duty to retreat anyway, as we just saw. There are other provisions of California law that give you special benefits for defending yourself in the context of your home, and those other provisions do care about how the person got in. But that's not castle doctrine. Those are those other provisions. Then this defense attorney Horowitz said, if the homeowner had any reasonable belief that his life was in danger, he had a right to shoot to kill. But that's got nothing to do with the castle doctrine, a castle, or your property at all. That would, to the extent it applies, and it's very incomplete, of course, you need more than just a reasonable belief you're in danger. You need not to have been the aggressor. You need to be using proportional force and so forth. But that would apply anywhere, right? You're in a public street. If you have a reasonable belief that your life is in danger and the other elements of self-defense apply, you have a right to shoot and kill. It's got nothing to do with your home. That's just a general principle of self-defense law. Still, Clark stressed that such killings are very fact-specific investigations and numerous other factors may be at play. For sure, we'll touch upon some of those. In all use of force cases, very small changes in facts lead to very large changes in legal outcome. Use of force cases are always extremely fact-specific. Continuing, that includes whether the burglar was inside the house or not, and whether he was fleeing at the time of the shooting. If a burglar is fleeing, let's presume empty-handed, what would be the justification of shooting him in the back as he's fleeing? Not self-defense, right? He's no longer presenting as an imminent deadly force threat to you, at least. Apparently not to anybody else. If he was presenting as an imminent deadly force against someone else, then it would be a defense of others scenario. But let's presume he wasn't. He's breaking in your window. You shout at him, "Go away, I've got a gun." And he runs away. And as he's running away, you shoot him in the back. Is that lawful self-defense? Nope. Is that lawful defense of property? No, even under special provisions. He's no longer trying to unlawfully enter your home. Now, I know a lot of you are saying, F around, F out, find out. I guess I can say the second F. F around, find out. And I understand why you feel that way. That's a normal human reaction, especially in a societal context like Oakland, California, where much violent crime simply is not prosecuted and punished. So our streets are plagued with these bad actors who ought to be in prison. But we as at least some parts of our society have decided that we prefer to have an under incarceration problem and lots of violent crime. That's the world we want to live in. So I understand why people would get frustrated and say, hey, if you tried to break into my house and now you're running away, it's like a military combatant who's running away, right? So under military rules of engagement, not the more recent wars of my lifetime, where the rules of engagement are highly politicized. Let's go back to traditional rules of engagement in war. World War II rules of engagement. If an enemy combatants can surrender, and then you're supposed to take their surrender, right? But if they're simply running away, they're still combatants. You're not obligated to let them run away, secure safety, and then come back and you have to fight them again the next day. You can shoot those combatants in the back as they're running away under traditional rules of engagement in military wars. But that's not true in a civilian context, certainly not in America, not even in Texas, which allows you to use deadly force in defense of personal property under the appropriate circumstances. But if the person who attempted to take or damage your property is running away empty-handed, you don't get to just shoot him in the back in retribution. So I'm sure that's one of the questions the cops are asking themselves. This guy is shot not in the home, but by the fence. At the moment he was shot, let's presume, we don't know. Maybe he was shot in the home and he fled, shot, and made it to the fence and fell over. That would be one set of facts. But maybe he was confronted by the homeowner, decided to desist in his burglary effort, ran away empty-handed, and the homeowner just followed him and shot him as he was trying to get over the fence and away. That's not a lawful use of force in self-defense or defense of property. That would just be murder. Maybe manslaughter. So the exact circumstances under which the shooting occurred matter to the police. What else do we have? Shavies, the assistant chief or whatever his title was, on Wednesday said investigators were still awaiting autopsy results to determine the specific nature of the other man's injuries, including, in particular, I would imagine, was the entry wound between the guy's shoulders, which is not definitive evidence of murder, but it would be certainly less favorable to the narrative of self-defense or defense of habitation than would be a entry wound to the front of the body. An autopsy has since been completed, but a final report is still being compiled, according to the coroner's office. No one answered a knock at the door of the man's house on Friday. Now, presumably, they took his illegal gun away from him, right? His illegal gun. I don't know if he has more guns, but if that was his only gun, and he lives in Oakland, and he's just been the subject of a burglary, and now he's disarmed in Oakland, and everyone in the world knows he's disarmed. Yeah, I'm not answering the door either. Especially not to talk to the media. Folks, never talk to the media. Never, ever, ever. Only bad things can happen to you from talking to the media. If the media needs to be spoken to, your lawyer does that. Okay, so let's begin now to look at some California law on defense of persons, defense of property. First, because we've been going so long, let me take a look at some of the comments and questions. We're going 45 minutes already. As always, folks, we only take comments and questions from our Law of Self-Defense members. We don't address comments and questions on YouTube unless they're a $10 super chat, which is crazy because you could be a member for a month, a Law of Self-Defense member for a month for less than $10. But if you do a $10 super chat, I'll take a look and address those questions and comments. I don't look at Rumble or Twitter at all for questions and comments. I do look at every question and comment submitted in the Law of Self-Defense chat, because we live stream this to the Law of Self-Defense membership. The good news is you can become a Law of Self-Defense member for dirt cheap, just 99 cents for a 2-week trial, folks. 99 cents. I know you have that under the floorboards of your car. Unlimited member access. Get all your questions and comments addressed. Get transcripts of every show. Every court case or statute or jury instruction we mention is hyperlinked in the blog, Law Self-Defense blog version of our content, which is available only to our members. All those benefits, just 99 cents for a 2-week trial at lawofselfdefense.com/trial. And after the 2 weeks, it's still dirt cheap. It's only about 30 cents a day, less than $10 a month, folks, to be a law of self-defense member. Less than $10 a month. But at least try it out for 2 weeks for 99 cents at lawofselfdefense.com/trial. And goes without saying, if at any time you decide it's not for you, you want to cancel, no questions asked. But we have very, very few people asking questions. And Shane is reminding me that we had a super chat from yesterday. I'll pull it up, Shane, and let me see. Maybe I'll answer it at the end of today's show. I think I really did cover it in the substance of yesterday's show, but I'll pull it up and to make sure I have it. Well, that's not what I wanted. Here we go. I'll pull it over there. All right. So, law of self-defense members. And if you go to that URL, lawofselfdefense.com/trial, sign up for the 2-week trial membership for 99 cents. You'll be immediately sent an email with how to join us on the live stream and take advantage of the live chat, which is what I'm looking at right now. Let's see. From when I was talking about crime statistics, Paul says there are 3 types of lies: lies, damn lies, and statistics. Indeed. Famous quote. Andrew says crime is down is good. A good thing because there are way more illegal guns out there. Robert says crime is probably going down now that we have 29 permitless carry states. Of course, it should be 50 permitless carry states. There was no concealed carry permitting process at the founding or immediately after the Civil War, which is the history and tradition standard of Bruin, of course. Let's see. Oh, Kent says this 77-year-old in California was held in jail for 48 hours. Thanks, Kent. I appreciate that. We saw in the news article, Kent again, the shooting was a Colt Python that had been reported stolen in Eureka, California. I tell you, man, the classic Colt Python, I believe they've brought it back, right? Is that true? Colt has begun making Pythons again. But the truth is, folks, there is no comparing revolvers, whether Colt or Smith & Wesson, of today and those manufactured, say, 40 years ago. The ones to get a gun of the quality, to get a gun today, a revolver today of the quality of 40 years ago, you'd have to send it back to the company's custom shop or some other competent gunsmith to be refined, to have that level of custom work done to it. In the old days, they would do that level of work, polishing and so forth, as a normal part of the manufacturing process. They don't anymore. Yeah, you have to pay extra to get that done. So if you're looking at a revolver, especially something like a Colt Python, and thinking about buying it, I'm not telling you not to. Just keep in mind, if it's from the 1970s or before, that's a different gun than if you're buying it in the 2020s. Let's see. As Zagusa says, I mean, you can shoot people on your property, just may not be the best idea, but it's physically possible. Right. It is physically possible. Let's see. Minnesota, apparently, Sakuza says, just says the waiting period to get a permit to carry in Minnesota is now 30 days instead of 7. So you apply, and then you need to wait 30 days to get permission to be able to carry a gun and defend yourself. Crazy. Kent says the Soros-funded DA in Oakland is facing a recall vote in November. Well, that would explain some of the political dynamics here, wouldn't it? This story would not be favorable to him if he starts prosecuting the 77-year-old. Favorable to him in his recall election. Will Parker says, how long will one have to weigh the weight of a charging decision hanging over their head? We had a defender from a potential mass shooting have to wait 25 months to find out he would not be charged, incurred $27,000 in attorney's fees also. Great question, Will. Will Parker, law of self-defense instructor, graduate of that program up in the Kalispell area of Montana, almost Canada. I'll be seeing Will in a couple weeks for a I'll be riding my motorcycle up to British Columbia and hanging out with Will on my way up there and attending a weekend shooting class by my buddy TC Fuller that Will is hosting up there. Check out Will Parker at FMGW, stands for Freddie Merck's Gunworks, fmgw.net. Great self-defense instructor. Has his own range and everything up there. Well, so the answer is there is no definitive timeline when your risk of getting prosecuted for some event goes away. I guess there's a statute of limitations that would explicitly prohibit the prosecution from bringing charges after the statute of limitations has expired, but there's no statute of limitations on murder. So if you've killed someone in purported self-defense and they want to charge you with murder, that can be hanging over your head forever. If you're lucky, you may get some kind of statement from the prosecutor's office saying that they don't intend to prosecute you. That's not an absolute bar on some later prosecutor from that same office deciding he does want to bring charges. It would be a pretty compelling argument for what's called estoppel in court, where you can say, hey, my clients relied on the representations of the prosecutor that they were not going to charge, so evidence has gone away. That would be exculpatory. And you could probably avoid prosecution on that grounds. But the prosecutor can just leave it open. The prosecutor can say, hey, it's still an open investigation. We reserve the right to prosecute. Could go on for years and years. Terry said, I heard people are leaving California in droves, seeing a lot more California plates here in North Carolina. Yeah, I've been in Colorado for 7 or 8 years now, and we are awash in California license plates, which is why I'm leaving Colorado. One of the reasons. Clay says, at 77, the homeowner should have requested an ambulance. In Texas, if they arrest you before you go to the hospital, the county has to pay the bill. So even though they'll send a cop with you and try to talk to you, you're not under arrest and have time for a lawyer to show up. Yeah, that's the rule in let me think. I think the rule in Georgia is the opposite. I think the rule in Georgia is once they cuff you up, they have to, and then if they take you to the hospital, they have to cover the expense of that hospital visit. So I've been told by senior local law enforcement officers in Georgia, who I'll leave unnamed. I don't know if they would want me to name them, but I've been told that it's not unusual where they might make an arrest. The suspect has to go to the hospital for some reason. They'll unarrest the suspect and bring him to the hospital. And then after the hospital visit, they'll rearrest him. So the county's not on the hook for the medical visit. Let's see. Kent says Dan Horowitz is Michael Savage's lawyer. Is Michael Savage the old TV show guy? That guy? I never really followed Michael Savage. Let's see. You can chase people off your property, even in California. You can use force to remove people off your property, simple trespassers. You just can't use deadly force to remove people off your property. Clay says he wasn't shooting to kill. He was just shooting to stop a threat. Yeah, that can matter. I mean, you're presumed to mean the reasonably predictable consequences of your actions. So if you shoot someone, your intent may be to stop them. It doesn't mean you wouldn't be on the hook for murder if they die and it wasn't self-defense. But the point is, self-defense the law of self-defense does not privilege you to kill people. That would be a privilege to execute. It privileges you to use deadly force if you meet the appropriate conditions. And as a consequence, the person may die. But the legal privilege is the use of deadly force, not the death. A subtle but important distinction. David says satirically, headline, local businessman killed by crazed homeowner. That wouldn't surprise me. Wouldn't surprise me. Kent says, yes, the Python is back. Well, that's interesting. I'll have to stop by my local gun store and take a look at one of those. Clay says, the old Colt Pythons were Cadillacs before the 90s. Yeah, they were. They were fine pistols. It doesn't say how long ago this Colt was reported stolen or when it was made. Remy says Oakland mayor is also facing a recall effort. Crime is one of the key elements. So it's weird, right, that the political environment should play such a big role in whether or not your use of force ends up being criminally charged, whether you're put to the hundreds of thousands of dollars expense of defending yourself in a murder trial, running the risk at least 10%, maybe 50% of being convicted in that trial, no matter how justified your use of force was, and spending the rest of your life in a cage. That thunderdome of legal consequences should so thoroughly be dependent upon the transient political dynamics of the moment in that jurisdiction. But that's part of it, folks. That's the reality of the criminal justice system. That's what makes the most operative word in that phrase, criminal justice system, is the word system. It's a system. It's like a steam era machine with giant gears. You don't want to be fed into that machine. By the way, the next most operative word in that phrase, criminal justice system, after system, is not justice. It's criminal. It's a system designed to process criminals. It doesn't do well with law-abiding people. And law-abiding people don't do well when they're fed into that system. Zakuza says, one of the reasons I'm looking to leave Minnesota is because they are trying desperately to become California. Yeah, Colorado has become California. We've got the Democrat supermajority in both houses in the legislature, in our appellate courts, in the governor's mansion, with the predictable results. Colorado is now one of the states. I talked about how unreliable crime statistics are earlier because reporting has ended in many places. But even the crime statistics we have, Colorado, I believe it's one of the top 5 most violent states in the country now. No reason for me to live here. All right. So that's the questions and comments so far. So and again, we only take questions and comments from our members. Try it out. 2-week trial membership, 99 cents at lawselfdefense.com/trial. After that, it's still only 30 cents a day, roughly less than $10 a month to be a Law of Self-Defense member. All right, let's take a look now at some law. So make this bigger. We'll take a look at some California statutes and jury instructions, a mix of the two. Statutes, of course, are law. Jury instructions are not really authoritative sources of law, but jury instructions tend to be an amalgamation of the statutory law and the appellate law, how the courts want those statutes applied to real people in real cases. And often they're more, because they combine statute and case law, they tend to be more fleshed out than either statutes or case law alone. And they tend to be written in plain English because they're literally the instructions given to a jury, non-lawyers, right? A lay audience, on how to apply the law to the facts of a case as the jury believes those facts have been proven or disproven. So, right to defend real or personal property. This is California Criminal Jury Instruction 3476. All the law we're covering, by the way, will be hyperlinked in the playback version of today's content if you're a Law Self-Defense member when you go to the blog. So if you'd like to be able to click and read this stuff yourself. An important point I want to make here is one of the elements of self-defense is proportionality. And proportionality has to do with the intensity of the force involved from 2 directions, right? The aggressor's intensity of force and your intensity of force. Because the amount of force, the intensity of force you're allowed to use is determined by how much force the aggressor uses. If the aggressor is only using non-deadly force, let's see if I can get my hand down here, low level of force down here, you're only allowed to use non-deadly force. You're not allowed to use deadly force unless the aggressor is using deadly force. That's the concept of proportionality. Now, the way the states often deal with this when they're writing statutes or jury instructions is they won't explicitly say non-deadly force. They'll just say reasonable force. But how you should read that, because this is how the courts apply it, is when it merely says force or reasonable force, what they mean is only non-deadly force. When they mean deadly force, they use the phrase deadly force or some synonym, force likely to cause death or serious bodily injury, which is what deadly force means. So when we're looking at right to defend real or personal property, so real property would be like land. That's real property is a legal term of art that means land. Personal property is just stuff, right? So the owner of real or personal property may use reasonable force to protect that property from imminent harm. So that would be taking or criminal mischief, damage, vandalism, destruction. A person may also use reasonable force to protect the property of, and this is really interesting. So this is one of the constraints, variables of defensive property law. Defensive persons law, defense of yourself, defense of others, is highly consistent across the 50 states. The biggest variable is the element of avoidance, whether you're in a duty to retreat state or a stand your ground state. It's about 80% similar across the 50 states. Now that 20% difference matters. That can be enough to put you in prison for the rest of your life. So you need to know the details of where you're defending yourself in that particular jurisdiction. But defense of persons law is very old law, and the fundamental underlying principle is very basic, right? You're maybe using force that threatens life in defense of life. But when we talk about defense of property, now you're using force that may threaten life in defense of stuff. That's a different balance, a different public policy question, and different states arrive at very different places. So every state has a provision for the use of non-deadly force to defend your property, your use of non-deadly force to defend your property. But often, there may be no privilege to use even just non-deadly force to defend someone else's property, especially a stranger's property. That varies a lot from state to state. So that old scenario where you hear a woman scream out in public, "Oh my God, that guy took my purse," and you see a dude hightailing it down the sidewalk with a woman's purse, and you tackle him to recover her purse, and you're the hero. In many states, you had zero legal justification for your use of force against that person to recover a stranger's property. And we see that reflected here in California law. The owner of property, this jury instruction reads, may use reasonable force to protect the property. A person may also use reasonable force to protect the property of not just anybody, not just a stranger, but only people in a special relationship to the defender. A family member, a guest, master, servant, ward, their property. Doesn't say stranger. Now, you can tell by the language here that this looks like an old statute, an old provision. This is an old jury instruction, right? So this language may come from an old case law, from a time when there were masters and servants and wards. But nevertheless, that's how the jury instruction still reads. Now, if we did a deep dive into California case law, more modern case law, we may find that the California courts have expanded this to include strangers' property. But I can tell you there are states in which it is the law that you have zero provision to use force in defense of a stranger's property. None. Continuing this, reasonable force means the amount of force that a reasonable person in the same situation would believe necessary to protect the property from imminent harm. They're using the word reasonable here twice in a single sentence. That reflects the weight and importance that this concept, this element of reasonableness, carries in the use of force context. And when they use reasonable force here, what they mean in the context of personal property and open land, not a habitation, that's different. We'll get to that in a moment. Real property, just open, unimproved land, is non-deadly force. If they wanted to allow for the use of deadly force, they would say so. They would say deadly force or force likely to cause death or serious bodily injury. When deciding whether the defendant used reasonable force, consider all the circumstances as they were known to and appeared to the defendant, and consider what a reasonable person in a similar situation with similar knowledge would have believed. If the defendant's beliefs were reasonable, the danger does not need to have actually existed. This goes to the question of the replica gun here, right? And the state has to disprove this defense beyond a reasonable doubt to overcome it. Now, the basic public policy balance here in 49 states is that human life is always going to be worth more than a piece of property. That's it. Piece of personal property, or in this context, real property, open, undeveloped land. 49 states, that's their public policy. Life is worth more than stuff. Now, I know some of you disagree. Some of you are of the sentiment that if you try to steal my stuff, you, the thief, are valuing my stuff more than you value your own life. I get it. I'm not unsympathetic. But here at Law of Self-Defense, we do what the law actually is, not the law as we'd like it to be. As we covered yesterday, you can look back at yesterday's show for this. Texas is the one provision that allows for the use of deadly physical force, deadly defensive force in the context of protecting even just mere personal property. That's Texas Statute 9.42. I'm not going to dive into that today, but if you'd like to check that out yourself, you can find that statute at this shortcut link that I created again just yesterday. Here it is, right there on the screen. lawofselfdefense.com/942. But in California and 48 other states, non-deadly force only in defense of personal property. Of course, we're not dealing here with just personal property, right? Oh, before I proceed on to that. So what about trespassers? Well, you also have a right to eject a trespasser from real property. Again, real property is land, right? Open, undeveloped land. We're not yet talking about a habitation. A habitation, a home, a dwelling, a castle is treated differently than simple real property. So just for purposes of completeness, the owner or lawful occupant, like if you're a renter of a home property, may request that a trespasser leave the home property. To leave, you're not welcome here. Trespasser, of course, is someone who has no right to be there. They're there. They need to be there by license, by permission. You can withdraw permission. Right now, they're a trespasser. If the trespasser does not leave within a reasonable time, and it would appear to a reasonable person the trespasser poses a threat to the home property or owner, occupants, the owner of the lawful occupant may use reasonable force to make the trespasser leave. Now, they have this reasonable time provision because it's not like you can tell someone, I invited you to this party, but you're acting like a jerk. So you're no longer welcome. Get off my property, and then instantly pull pepper spray and spray them down. You have to give them a reasonable opportunity to obey the lawful instruction to leave the property. But if they don't do that, if they don't take advantage of a reasonable time to leave the property, then you can use reasonable force to make them leave. Again, this is going to be non-deadly force. So you can take them by the arm. Maybe you could pepper spray them. Though then if you're going to handle that person, you're getting pepper sprayed too. But you can use non-deadly force to remove a simple trespasser. If they stop being just a simple trespasser and they start becoming a threat to persons, right? They're resisting your use of force. Maybe they pull out a weapon when you try to lawfully use non-deadly force to remove them. Well, then it's not a trespasser situation anymore. It's not a defensive property situation anymore. Now it's a defensive person situation. And the normal defensive persons law would apply with the 5 elements of self-defense. By the way, we make this little cheat sheet available for free, folks, to everybody. It lists the 5 elements of self-defense, defensive persons, and it provides a brief description of those, and it's free. We don't charge a penny for this. It's just a PDF download. If you don't understand these 5 elements, you can't possibly understand self-defense law. Get it for free at lawofselfdefense.com/elements. Free, folks. We can't make it cheaper than free. So this continues. Reasonable force means the amount of force that a reasonable person in the same situation would believe is necessary. That's going to mean non-deadly force, unless the trespasser escalates to a deadly force level. If the trespasser resists, the owner may increase the amount of force he uses in proportion to the force used by the trespasser and the threat the trespasser poses. So again, the amount of force you're allowed to use is governed by the amount of force being used by that aggressor party, whether they're a trespasser or whether they're acting aggressively towards a person. Consider all the circumstances. The state has the burden of proving. So that's dealing with simple trespassers. The next one, California law I wanted to cover, was the statute. Statute 197, justifiable homicide by other persons. They say other persons because the statute preceding this was justifiable homicide by law enforcement. So this is just by normal people, right? Non-law enforcement, the traditional self-defense context. So in the California law, when can you lawfully commit homicide. Homicide just means one human killing another human, right? So sometimes that's illegal, in which case it would be murder or manslaughter. And sometimes a homicide is legal, as in lawful self-defense. So here, California says homicide, one person killing another person, is justifiable when committed by any person in any of the following cases: when resisting an attempt to murder any person, or to commit a felony, or do some great bodily injury upon any person. So if that bad actor, that unlawful aggressor, is attempting to commit death or grave bodily injury upon someone, you can lawfully kill that person. That's a justifiable homicide. When committed in defense of habitation, property, or person, against one who manifestly intends or endeavors by violence or surprise to commit a felony, or against one who manifestly intends and endeavors in a violent, riotous, or tumultuous manner to enter the habitation of another for the purpose of offering violence to any person therein. So we're going to look at some other law here from California that looks at defense of habitation in particular. Habitation is mentioned kind of in passing here, but they have specific law just on defense of habitation. When they talk about property, we would actually refer back to the defense of property statute here to decide whether or not this was reasonable use of force. And they have this language, violent, riotous, or tumultuous manner to enter the habitation, because they're trying to distinguish here between someone who's unlawfully present in a habitation or trying to unlawfully enter a habitation innocently, without malice. Earlier, I talked about the repairman who sent to the wrong address by accident, told the door will be open because the homeowners can't be present. They have to be at work, but they want their dishwasher repaired. And he goes to the wrong address. He's sent to the wrong address. And sure enough, the door's open and he walks in. Well, he's there unlawfully in that wrong address, right? He does not have license to be in that habitation. But he's not there with malice. He's there innocently. That's different than someone who uses a crowbar or force, riotous, tumultuous manner to enter the home. There's no innocent explanation for why someone's unlawfully in the wrong property. So that's why they're trying to make that distinction there. Then they have a defense of others perspective provision, and to apprehend someone for a felony, really a citizen's arrest provision. Well, I'm not going to cover that today. We'd be here for another couple of hours. I would just caution you against making a citizen's arrest. Didn't work out too well for the people in the Ahmaud Arbery case, did it? Then we have the jury instruction on justifiable homicide, self-defense or defense or another. So it's jury instruction 505. We already looked at a provision of this about the duty to retreat. It's a very long jury instruction. It does more than just reflect the statute on justifiable homicide, which we just looked at. It incorporates other scenarios. It incorporates case law, like the duty to retreat. The California justifiable homicide statute doesn't ever mention whether or not there's a duty to retreat, but we find that in the jury instruction on justifiable homicide because the jury instruction incorporates both statutory law and case law, which is where California's stand your ground provision comes from. So this is really defense of yourself or defense of another. And that's independent of where you are. You could be in your home, you could be in your yard, you could be out in a public street. It's independent of location. Then we have defending against harm to a person within a home or property. Now we're bringing the habitation into this. This is California Jury Instruction 506, the one that immediately follows 505. Did I bring it over? Here we go. Justifiable homicide, defending against harm to persons within a home or on property. The defendant's not guilty of murder, manslaughter, or attempt of either, so not guilty of an unlawful killing. If he killed or attempted to kill to defend himself, well, that's just straight up self-defense, right? Or another person, well, that's just straight up defense of others. In the defendant's home. So you don't even really need the defendant's home here. But it does bring in some additional provisions that are important to this narrative. Such a killing or attempted killing is not unlawful if the defendant reasonably believed he was defending a home against the aggressor who intended or tried to commit violent, riotously, or tumultuously tried to enter that home, intending to commit an act of violence against someone inside. Now, notice the word "and" here. So all these numeric provisions are cumulative. They're all required. If one is missing, you don't get the benefit of this justification. So you have to believe all of that. The defendant reasonably believed the danger was imminent. The defendant reasonably believed the use of deadly force was necessary. The defendant used no more force than was reasonably necessary to defend against the danger. So we have 4 enumerated conditions here that are cumulative. Every single one of them includes the word reasonable or some variation, reasonably. Again, this reflects the weight of the element of reasonableness that the law gives that element in the use of force context. And I caution, it's not your determination of reasonableness that decides your legal fate. It doesn't really matter what you thought was reasonable. I mean, there is a subjective requirement, supposedly, that you believed it was reasonable. But what really determines your legal outcome is what other people believe is reasonable, what the prosecutor thinks is reasonable. Because if he thought it was unreasonable, he's going to believe he can charge you. If the judge believes your use of force is arguably unreasonable, that argument can credibly be made. He's going to allow you to go to trial. And if the jury believes your conduct was unreasonable, they're going to convict. And it doesn't matter how reasonable you thought it was. So this assessment of reasonableness, keep in mind, is always being made by other people in complete safety whose interests may not be aligned with your interests. They may even have a political motivation for finding your conduct unreasonable and therefore unlawful and therefore convicting. So every time you see this condition of reasonableness, that should alarm you, because that is a vulnerability of your claim of justification that's totally outside your control after your actual use of force. Belief in future harm is not sufficient. This goes to the element of imminence. You have to be defending yourself or your property against a threat that's actually happening, not some past or future threat. The defendant must have believed there was an imminent danger of violence. Defendant's belief must have been reasonable. You can only use the amount of force that a reasonable person would believe necessary. That's proportionality. Consider all the circumstances. You're not required to retreat. The state has to disprove beyond a reasonable doubt this claim of self-defense. So that's all the defensive person's jury instruction. Now we get to one of the special provisions. One of the special provisions for the use of force in defensive habitation that's separate from straight up self-defense or defense of others, which would apply in the street. And it's separate from the castle doctrine, which merely relieves you of an otherwise existing duty to retreat. That's all castle doctrine does, is address the element of avoidance. These special provisions in California and many other states have similar provisions, create a legal presumption that these elements have been satisfied, which is great for the defender. So let's take a look. Statute 198.5, presumption in favor of one who uses deadly force against an intruder. What's an intruder? An intruder is someone who's in your home without license. Arguably someone who unlawfully, forcibly, riotously, tumultuously entered your home. So they're not an innocent intruder. They're an intruder there presumptively with malice. Any person using force intended or likely to cause death or great bodily injury, so deadly defensive force, within his residence shall be presumed to have held a reasonable fear of imminent peril of death or great bodily injury to self, family, or member of the household. Even not a member of the family or household. When that force is used against another person who's not a member of the household, so not a domestic situation. If it's a domestic situation, this legal presumption wouldn't apply. But you're using force, deadly defensive force, against someone who's not a member of the family or household, and that person is unlawfully and forcibly entered, or he enters or has unlawfully and forcibly entered, and the person using the force, the defender, knew or had reason to believe that person unlawfully and forcibly entered. So what is this reasonable presumption giving you? Keep in mind, there's up to 5 elements of self-defense, right? Innocence, imminence, proportionality, avoidance, and reasonableness. Avoidance is off the table in an otherwise lawful case of self-defense, both because California is a stand your ground state, and second, because even if California were a duty to retreat state, Castle Doctrine would relieve you of that otherwise existing duty to retreat in your home when defending yourself in your home against an intruder. So there's no avoidance. So that leaves 4 elements: innocence, imminence, proportionality, and reasonableness. This legal presumption gives you reasonableness. It says it's presumed that the defender had a reasonable fear. So now there's only 3 elements, right? Innocence, imminence, and proportionality. It also presumes that the threat is imminent. Now there's only 2 elements left: innocence and proportionality. And it presumes the nature of that threat is one of death or great bodily injury. Well, that's proportionality. Now there's only 1 element left. Castle Doctrine took avoidance off the table. This legal presumption took reasonableness, imminence, and proportionality off the table. The only one of the 5 elements left is innocence. And innocence is rather baked into the cake if you're in your residence and you're dealing with an unlawful enforceable intruder. So this is a great scenario for the home defender who's defending against an intruder who's entered in a riotous, tumultuous, unlawful, forcible way into the home. It's basically giving you everything you need for your use of deadly defensive force to be justified in that scenario. It's pretty hard to screw up for the defender. That said, defenders do screw it up. First of all, this is a rebuttable presumption, so it can be overcome by other evidence presented by the prosecution. Say, for example, the person you're claiming was an unlawful enforceable intruder was actually a business partner with whom you were having well-documented argument sufficiently severe that a person might be motivated to kill over it. In fact, you'd written out a detailed plan for this killing. Step 1, fake a break-in, right? And then they find broken glass on your sleeves. So the prosecution can say, well, we don't believe it was a legitimate, a genuine, forcible, unlawful entry. We believe the defendant fabricated the circumstance. That's the kind of evidence that could rebut this legal presumption. So it's rebuttable. Also, it ends. It has a time ending. So imagine someone meets all these conditions, right? They're an unlawful, enforceable entry, and they do all this, but they escape. And a month later, they're caught by the police. And a month after that, they're brought to trial. And in the midst of their trial for this burglary, you manage to sneak a gun into the courtroom and you shoot them dead. Could that use of deadly force be justified as defensive habitation? Obviously not. So the fact that all these conditions were met does not give you an infinite license to use deadly force in that person. Your use of force would have to be within the context of these conditions. Meaning, if you shout at this person who's forcibly unlawful entering, now you could just shoot them, right? And be presumed to be entitled to do that. But what if instead of shooting, you yell at them, "Get out, I have a gun," and they run away? And they're fleeing across your backyard, empty-handed, no weapons, no property, and you shoot them in the back of the head. Would that fall within these conditions? No. No. Does that look like defense of persons? Nope. Does it look like defensive habitation as provided here? No, it doesn't. That looks a lot like murder. And if you argue that you had a heightened emotional state because of the burglary, maybe manslaughter, maybe voluntary manslaughter, which is a mitigated form of murder. Let's see. So that was the statute that provides that legal presumption of a reasonable fear of imminent deadly force harm. There's also a jury instruction that does the same thing. I'm not going to read it because it just parallels the language of the statute, but I just wanted you to be aware that jury instruction also exists. And that's most of the hard law I wanted to cover. So Why might this 77-year-old homeowner be legitimately subject to arrest, prosecution, and convicted for murder when he shot a burglar? Well, because he might have shot the burglar under circumstances that don't fit any of the legal justifications. Now, the state would have to prove that beyond a reasonable doubt. And frankly, the homeowner does run a risk of, if he's, now he didn't give a statement to police apparently, which is fine. And indeed, it's better than fine. It's prudent to do that. And of course, once he gets to trial, if he were to go to trial, he cannot be compelled to testify against himself, to take the stand and explain to the jury what happened. There is a burden of production that has to be met on the justification of self-defense or defense of property. So any of these justifications, as you can see, they have elements, right? Here we see 1, 2, 3, 4. These are elements of this legal presumption. You can't just make legal arguments in court in the absence of evidence. There needs to be some evidence to support your legal argument. In this case, because these 4 elements are cumulative, there needs to be evidence to support each of those cumulative elements. And the same is true for killing in self-defense, right? We see 1, 2, and 3. There are cumulative elements here. Before you're allowed to argue self-defense in court, before the jury would get a self-defense or defense of habitation jury instruction, the prosecution can say, Your Honor, those jury instructions are not warranted because there's zero evidence on one or more of the required elements. And the only role of a jury is to consider evidence. They're the finders of fact. If there's zero fact for them to consider on a legal issue, there is no legal issue, because the legal issue doesn't exist absent some kind of factual evidentiary foundation. And if the prosecutor says, hey, there's, say killing in self-defense, hey, there's zero evidence to support element number 3 here, you don't get the defense. So that's called the burden of production. It's required. It's the burden on the defense to produce more than zero evidence in support of each of the required elements of a legal defense in order for them to be able to raise that legal defense, that legal argument before the jury. That burden of production is on the defense. Now, it's not much evidence. It's more than zero. It could be 1%. It could be contested evidence. It could be hard to believe evidence. It could be self-serving evidence. It could be the defendant's own statements. It could come from any source. It could come from witnesses. It could come from state witnesses, presumptively hostile to the defense. But it needs to exist. Once the burden of production is met, then the burden of proof shifts to the state. They have the burden of persuasion to disprove the legal defense beyond a reasonable doubt, but only once the burden of production has first been met by the defense. So somehow the defense may be obligated by the prosecution to meet their burden of production. And where's that evidence going to come from? Now, again, it could come from witnesses. It could come from surveillance cameras. It could come from the bad actors themselves. Might make a statement to police that would include within it, unintentionally, the evidence needed to meet the burden of production. But if it doesn't come from any other source, and I just consulted here at Law Self-Defense on a case for a platinum member where the circumstances were really a he said case. I'm very much abbreviating the facts, but in essence, it came down to that. You had the member had used force against somebody, was claiming self-defense, had not made a statement to police. So the only statement in the record was from the person, the victim, the person against whom the force had been used. Now, of course, the law self-defense member, the defendant in the case, they communicated with me and with their lead counsel. So we know his side of the story. But for the defendant to get his side of the story before the jury, it's probable he's going to have to take the witness stand. Now, he has a Fifth Amendment right not to testify. That's fine. He can assert that right. But then the jury may never hear the defense side of the story as evidence. Now, they may hear it in opening statement and closing argument, but they're told opening statement and closing argument are not evidence. And it's possible if this 77-year-old homeowner were prosecuted and brought to trial that he may be compelled to take the witness stand to provide the evidence needed for his burden of production. Now, he may not. I mean, there's evidence in the record, right, from which a a narrative of defense can be crafted even without the homeowner testifying. We're lucky that's the case. Like the bad actors had a crowbar. Maybe there's damage to the home, right, from the crowbar. I mean, that's evidence of a burglary, that kind of thing. But that wasn't, that's just good luck in an ironic sense for the homeowner. He didn't give the burglars a crowbar to bring to the scene. They made that decision, and that provides evidence that turns out to be favorable for the homeowner, not within the homeowner's control. All right, so let me look back at the comments and questions, see what is new. And again, we only take comments and questions from our Law of Self-Defense members. So I would encourage you to become a member at lawofselfdefense.com. In fact, this show was a little unusual in that I took questions in the middle because I knew it's a long show and I knew they would accumulate. But when we get to this portion of the show, normally the Q&A at the end of the show, the live streams on YouTube, Rumble, and Twitter end. And we're at that time of the show, folks. So I'm going to start doing the wrap-up Q&A and addressing comments from the Law of Self-Defense members. You can become a Law of Self-Defense member for just 99 cents. A 2-week trial membership at lawofselfdefense.com/trial for 99 cents. You'll be immediately emailed how to join us in the live stream for members. Put your comments and questions in the chat. 99 cents, folks. And after the 2-week trial, it's still dirt cheap. It's only about 30 cents a day, less than $10 a month to be a Law of Self-Defense members, and get your questions and comments addressed for free. Or if you're on YouTube, they can be a $10 super chat, but we're about to cut off the YouTube stream anyway. So I really don't encourage you to do the super chat thing on YouTube. And we don't even look at questions and comments from Rumble and Twitter. So if you're on Rumble, watching this on YouTube, Rumble, or Twitter, this is the end of the show for you. I'll just remind all of you that if you carry a gun, so you're hard to kill, so your family is hard to kill. That's why I carry a gun, have for well over 30 years. So me and my family are hard to kill. If that's what you do, then you also owe it to yourself and your family to make sure you know the law so you're hard to convict as well. If you're a Law of Self-Defense member, don't go anywhere. We'll take a 20-second break while I cut off the other streams, and we'll be right back with the membership. To those of you on YouTube, Rumble, and Twitter, stay safe.